An almost 6-hour hearing in the High Court today saw a dramatic twist in the highly anticipated trial of S Iswaran, the former Transport Minister convicted on charges of receiving gifts while in office. At the start of the trial, a decision by prosecutors to replace 2 corruption charges with 2 lesser charges under Section 165 of the Penal Code. The prosecution stressed that the corruption charges were not withdrawn, but amended, and there was good basis for those charges. It saw the trial proceed with only 5 charges, including 4 offences related to public servants obtaining valuable things and 1 charge of obstruction of justice. The 62-year-old admitted to all 5. The court judge said the remaining 30 charges Iswaran faces will be taken into consideration in deciding how he will be punished. Prosecutors are seeking 6 to 7 months in prison combined for the charges, while the defence is hoping for no more than 8 weeks. Sentencing has been set for next Thursday. The court also heard that Iswaran voluntarily paid back more than $380,000 to the state a day before the trial. Here's a look at the 5 charges Iswaran pleaded guilty to. Now, in September 2017, Iswaran obtained 10 green room tickets to the 2017 Formula One Grand Prix from Malaysian billionaire businessman Ong Beng Seng. These tickets were valued at more than 42,000 Singapore dollars. In December 2022, Iswaran took an outbound flight on a private plane from Singapore to Doha, stayed a night at the Four Seasons Hotel Doha, and took a business class flight from Doha back to Singapore. Now, these were all once again paid for by Ong, valued at more than $20,000. In May 2023, Iswaran obstructed justice by making a payment of $5,700 to Singapore GP Private Limited for the cost of a business class flight ticket from Doha to Singapore. The flight was at the expense of Mr. Ong through Singapore GP. Now, in January 2022, he obtained 14 bottles of whiskey and wine from Lam Kok Seng, the director of Lam Chang Holdings. It is a construction firm that's currently involved in multiple Singapore government projects. The alcohol was valued at about $3,200. And in June 2022, Iswaran obtained a Brompton T-Line bicycle from Lung, valued at almost $8,000. CNA reporter Jeraldine Yap was there for today's proceedings and tells us how the trial unfolded in the High Court.
It was described as a one-of-a-kind criminal trial in recent history. Just after 9 a.m. at Singapore's High Court, former Transport Minister S Iswaran, flanked by his lawyers, arrived to a barrage of cameras and microphones. He gave a brief greeting to members of the media before entering the building. All eyes had been on this day, with about 40 members of the media and public packing the courtroom for the 10 a.m. start. Among them, Iswaran's wife and family. Then came the first twist of the day. The prosecution moved forward 5 lesser charges only, including some related to billionaire property tycoon Ong Beng Seng. 2 corruption charges Iswaran had originally faced were amended at the 11th hour to charges of obtaining valuable items as a public servant. Iswaran's lead lawyer, Davinder Singh, said his client would be taking, quote, a certain course of action given this development. It was the first sign of what was to come. Then, confirmation from the man himself. He rose before the judge and pleaded guilty. It was the second surprise of the day in this highly watched trial. Iswaran's admission coming on the back of a promise to prove his innocence. Mr. Singh said the guilty plea didn't come earlier because Iswaran did not agree with the corruption charges. Both sides then made their sentencing submissions, the prosecution arguing for a jail term of 6 to 7 months and the defence a jail term of no more than 8 weeks. Among the mitigating factors cited by the defence, one was that Iswaran had paid about $380,000 back to the state and surrendered other gifts he had received, including alcohol and golf clubs. And this was done immediately after he was informed of the amended charges. The defence also said that Iswaran's charges had caused minimal to no harm to others, a point that the prosecution disagreed with. The prosecution said that the government's impartiality had been impacted by the case. The prosecution and defense also clashed on various other points. The prosecution argued that the charges Iswaran faced required no quid pro quo on the part of the public servant. The defense, however, said the gifts were given to Iswaran in the context of his friendships with Mr. Ong Beng Seng and Mr. Lam Kok Seng. For example, Mr. Ong had invited Iswaran on the trip to Qatar, which he took urgent personal leave to go on. Throughout the exchange, Iswaran was seen occasionally taking notes, at one point shaking his head during an argument between the lawyers over the basis of the initial corruption charges against the former public servant. The hearing was then adjourned and Iswaran left the court at around 4 p.m, stopping briefly to address the media.
As you know, my lawyers have stated the position clearly, and as you're well aware, the matter is now sub judice. So it's not appropriate for me to say anything more.
The judge has asked both sides for more submissions by Thursday. Iswaran will be sentenced next Thursday.
The Attorney General's chamber says it considered several factors in deciding whether to amend the corruption charges against S Iswaran. One was the litigation risks involved in proving the charges beyond reasonable doubt, given that there are two primary parties to the transactions and both would have an interest in denying corruption. AGC also considered whether the amendment would lead to a fair and just outcome that is in line with the public's interest. It adds that it will soon take a decision on Mr. Ong Beng Seng. A lawyer CNA spoke to said he has never seen a case that reduced a corruption charge to Section 165 of the Penal Code. That is, as the two charges have different requirements, even though Section 165 is also part of wider anti-corruption measures in Singapore. Stephen Lam from Templars Law said the key difference is that of dishonest intent, which is not required in Section 165. But the practice of getting corruption charges downgraded to charges other than Section 165 is common.
Sometimes looking at the facts of the matter, some of the elements of the charges may not be so easily proven by the evidence. But nevertheless, on the face of it, there seems to be an offence, albeit of a not so serious nature. So that will usually result in a reduction of charges. That's one possibility. Second possibility, and which sometimes happen, is two negotiations between defense and prosecution, whereby the circumstances are not so aggravating. Prosecution sometimes would also agree to a reduction of the charges.
Iswaran had two initial corruption charges replaced with the lesser charges of obtaining gifts as a public servant under Section 165 of the Penal Code. So how are offences under Section 165 different from those under the Prevention of Corruption Act? Now, Section 165 has been in the Penal Code since it was introduced in 1871. It penalises public servants who accept gifts from an individual who is involved with them in an official capacity or has official dealings with. But it doesn't involve giving or doing anything in return. Those convicted can be fined or jailed up to 2 years or both. Now, the Prevention of Corruption Act defines the primary offences of corruption and the punishment here. Introduced in 1960 is also the primary anti-corruption legislation. Under this act, prosecution must prove that a favour was given in exchange for the gratification. Now, for each offence, those charged can face a jail term of up to 7 years, a fine of up to $100,000 or both.
For Section 165 of the Penal Code, it's quite a straightforward offence. If you're a public servant and you have a business relationship with somebody, you cannot take any gifts. And if you take gifts, it's an offence. Simple as that. Because you're put in a position of conflict of interest. Now, for Section 6 of the Prevention of Corruption Act is slightly different. It usually requires an element of quid pro quo. That means there's a favour given or something like that.
And we're going to check in with Associate Professor of Law Eugene Tan. He joins us live from Bangkok. Prof Tan, welcome. Now, the prosecution is seeking a 6 to 7 month jail term, while defense is calling for no more than 8 weeks here. What is the maximum penalty under Section 165 of the Penal Code, and what sort of considerations will the judge be taking in deciding if his conviction merits a jail term?
Well, 165, when someone is convicted on a charge, the penalty could range from a fine or a jail term of up to 2 years, or both. So what sort of penalty will be meted out by the court will obviously depend on a variety of factors, ranging from the degree of culpability of the accused person. The court will probably also look at, the duration of, the offences, the harm, that may have been inflicted. Here, we're talking about trust and confidence in the government, the impartiality of the government. The court may also look at whether, there has been abuse of trust where the accused person is concerned. But that will have to be balanced against, any mitigating factors, such as taking the first opportunity to plead guilty, and any other factors, that are relevant and favorable to the accused person. So we saw from today, there have been differences as to, what are applicable or not, and it's really now for the judge, to decide what factors are relevant and applicable.
Looking at the number of charges against Iswaran, we're looking at from 35 down to just 5 for taking gifts as a public servant. All 2 charges of corruption dropped. Now, what does all of this say about the prosecution's case against Iswaran?
Well, I think despite, the amended charges, despite the prosecution now not proceeding, on any of the Prevention of Corruption Act charges, I would say that the prosecution stuck to its guns. I think they take the view that Section 165 of the Penal Code is a corruption type offence. And I think when you look at the arguments that were tendered, by the prosecution with regard to after Mr. Iswaran had pleaded guilty and then the focus shifted to, the sentence. I think, one can say that, the prosecution, isn't giving Mr. Iswaran, any favorable treatment. I think, the prosecution has been very clear, that Mr. Iswaran had put himself in a potential conflict of interest, and that could be a precursor, to corruption. But in any case, they wanted the charges, to reflect, that the AGC had zero tolerance, with regard to corruption and or corruption type offences.
But Prof Tan, what could be some of the reasons why prosecution would want to set aside or amend a serious charge like corruption?
Well, Shaida, in the earlier part of this package, I think, it was mentioned that there could be the possibility of a litigation risk. I mean, the demands on the prosecution with regard to a Prevention of Corruption Act charge is certainly more demanding, right? We heard from another lawyer, the need to show that there was a favor in exchange, for a favor. So each party giving the other, favors in return, for certain outcomes. In Section 165, there isn't that particular requirement. But what we can see here really is, the prosecution is aware that, its task is not to secure conviction at all costs. And given the litigation risk and the focus on ensuring that, public resources are properly expanded, I think, the prosecution has taken the view, that amending the Prevention of Corruption Act charges to Section 165 Penal Code charges would still amount to a reasonable and fair outcome for the ends of justice. And in this case, that also includes Mr. Iswaran being held accountable for his actions, and that, the important public values of incorruptibility and the rule of law, that they are reinforced as well.
Meanwhile, the AGC, Prof, has said that it will make a decision on property tycoon Ong Beng Seng. What happens now to people like him, people like Lam Kok Seng, who gave gifts to Iswaran, now that no witnesses will be called for prosecution and defense since Iswaran has pleaded guilty?
Well, I think the prosecution will take one step at a time. I think the main priority now is to deal with the case against Mr. S Iswaran, and when finality has been reached, with regard to that case, they will then look into the facts and to see whether charges could be proceeded against Mr. Ong Beng Seng as well as Mr. David Lam. So I think one could say that both gentlemen, Mr. Ong and Mr. Lam, they are not off the hook yet, and we can expect, that there will be close scrutiny, not just by the public prosecutor, but also, by the public. I think there is certainly the expectation, that something would be proceeded against, both gentlemen. But I think it's still too early because the case against Mr. Iswaran has not fully resolved yet.
Before we go, Prof, will this case against a former minister, once a key member of the ruling PAP, have any impact on the sitting government? This is a much anticipated trial we're looking at here.
Oh, definitely, right? And I think it is a setback for the ruling party and the government, right? Because this is a government, that's prided itself in high public life standards as well as incorruptibility. But I think fair-minded people will also recognize, looking at how, the public prosecutor as well as the government, handled this matter, and that included the CPIB, the anti-corruption watchdog, that there should be little doubt, that there is that strong abhorrence of, corruption. I think here we are dealing with, the unfortunate condition of human frailties. But I think what is really important is to see, how the system, responded when there were these allegations, of wrongdoing. But ultimately, people would have made up their minds, as to what they think about the system and whether they think, that Mr. Iswaran has been properly dealt with.
Okay.
But I think, when we look at the matter in its entirety, I think we can go away feeling assured, that zero tolerance, has been made clear, and that, the rule of law as well as due process, applied. And I think that's something that, we want, regardless of whether, we think, how we view, this entire episode.
Okay, Prof Tan, thank you very much for sharing your insights with us. That was Associate Professor Eugene Tan from the School of Law at SMU.